Welcome to the Real Estate Power Play Podcast, your launch pad for skyrocketing success in real estate investing. I'm your host, Gabe Rodarte, alongside Mark Monroe. We're ready to bring you transformative stories, groundbreaking strategies, and the insider secrets of real estate giants. Get ready to accelerate your investment journey and become a true power player in the world of real estate.
Welcome to another episode of Real Estate Power Play. I am the host this week, Mark Monroe, and I'm excited about having a special guest on. And I was actually on his podcast a couple weeks ago, and I really enjoyed it because not too many people at the same mindset as like Joe is, and in the creative seller financing world and understanding and how to make deals structured, how they work. And Joe specializes in trust. Joe, welcome, and why don't you go ahead and introduce yourself a little bit to everybody? And I'm so excited having you on. Thanks for joining us.
Well, thanks for having me. It's great to be here. I'm Joe Seagle. I'm a real estate asset protection lawyer for Florida entrepreneurs. We especially focus on real estate investors in Florida because they tend to have a lot of real estate. And we find that a lot of other law firms don't really deal with real estate investors in particular inside of Florida when it comes to asset protection and estate planning. So we focus on that. And prior to that, I've always been a lawyer. I've been a lawyer since 1996. I've been practicing law, practiced in North Carolina, South Carolina, DC, Florida. I came in 2001 and started practicing law down here. Had a couple of title agencies, so did thousands of real estate closings, again, focusing on real estate investors. So I know what kind of crazy deals they always have and what kind of crazy title problems they have. Dealt with that for about 25 years doing that. Sold my title agency is off in 2022. In 2023, I already had a land trust company, and we were trustee of about 400 land trusts across Florida. And I acquired Land Trust Service Corporation, Mark Ward's company, in early 2023, and merged that with, or combined it with my land trust company. So now we are the largest land trustee in the state of Florida, holding over 2,000 properties in trust at any time across the state of Florida. We're in every county except two. There are two counties, I guess, that just don't have enough people in them to even worry about land trust. And we keep people's ownership of their real estate secret. And a lot of those people are real estate investors, they're entrepreneurs, they're creators, they're billionaires, millionaires, doctors, and other people who face a lot of liability, but they just don't want their name on the title. So we are the name, we're the face of the property out there to keep their name off title, provides them anonymity and asset protection both at the same time, while with some estate planning thrown in there for them. So that's basically what we do.
It's a little big of a nutshell. That's great. I love it so much, especially in a land trust. When I'm doing a lot of my properties in buying properties, especially like through seller financing, I'm putting every single one into a land trust, if you will, just mainly for, protection. Now, correct me if I'm wrong, but it really doesn't, land trust doesn't really create that vehicle, doesn't really create asset protection. It's more anonymity. Is that correct from what I understand?
Anonymity, number one, asset protection, number two. I, along with Mark Warden and a bunch of other lawyers across the state, we sat on the last two subcommittees of the Florida Bar's Real Property and Trust Law Subcommittee on Land Trusts, is what it was back then. And in 2013 was the last time we did a major overhaul of the land trust statute in Florida. In 2009, we did it before. So we helped write those, and Mark and I sat on that committee. And with our experience being trustees and my experience of being in title for so many years, and being lawyers as well, and knowing what our clients were looking for as far as asset protection, we wrote that statute to provide a lot of asset protection. So they do, land trust, much like an LLC, they separate the property away from you. They separate it away from everything else you've got and all your other properties. And you just have a beneficial interest in the trust. So they do provide a good bit of asset protection in Florida. Other states, not so much, but definitely in Florida, and even in other states, there's ways to get around it to get you some more asset protection. But in Florida, with our statute and the way we helped write that thing, we made it pretty airtight when it comes to asset protection. We were pretty tight about that.
Now, is that why in I'm not by far I'm not an expert in land trusts and how they're doing, but I know a lot of people will use a Florida land trust, even putting a property in another state. Let's say, for example, in say Massachusetts, or say, why do they use a Florida land trust if the property is in another state?
Well, it's interesting. We've actually got a case in Florida where the Florida Supreme Court, there was a property that was in North Carolina, and it was held by a family member who also happened to be a lawyer. And he was the trustee of this trust that he had created, a land trust here in Florida, to own the property in North Carolina. And when there was an argument between the trustee and the beneficiaries, because they're all family members, and where there's a will, there's a relative, they all got angry with each other and they went after the brother, cousin, uncle who was the trustee of this trust. They brought that suit in Florida. And the Florida Supreme Court never questioned that the fact that this Florida land trust was owning property in North Carolina, because the way we wrote the statute, the trust, the Florida land trust, simply has to hold an interest in real estate, not necessarily Florida real estate. So timeshare companies have really taken that and blown it up. I mean, they've formed Florida land trusts, especially here in Orange County in Orlando, where the timeshare capital of the world is. And they now deed, many of the big developers, they deed properties in Arizona, California, Texas, Maryland, Virginia, North Carolina, South Carolina. They deed them all to a land trustee here in Orange County, Florida. So now all of that property is owned in all these different states by the trustee here in Florida. And those trustees happen to be licensed title insurers like First American or Fidelity or big insurers who also are licensed to do business in all those other states already. And they're insurers, they're highly regulated. So they deed them in, and so it is very common, and it's massive. I mean, there's billions and billions of dollars worth of property, timeshare property from all over the country that's held by trustees in Florida land trusts right here in Florida. So it can be done. It's perfectly allowed to be done. The problem we have with it is we're not licensed as a trustee in all those other states. You typically, in a lot of other states, to be an entity that is a trustee of other people's property, you have to be a bank, a non-depository bank, a trust company that is licensed, bonded, insured, and capitalized to do business in that state, like in South Carolina or Virginia. And we're not like that. So we stick to Florida. But we tell people all the time, it's like, well, if you've got a company that you know that you are, or maybe an individual who lives in that state, in North Carolina, South Carolina, whatever, and you want to convey it into a land trust, we're happy to do the land trust here in Florida and set it up. And we can even get the deed from that property in that state into your trustee. And now you've got a Florida land trust holding property in wherever you may be. And then, yeah, if there's a dispute, it's typically going to be handled down here. And the Florida Land Trust says that all title, equitable and legal, is in that trustee. So no one has any reason to ever see the trust itself. I did closings in North Carolina for years before I moved here to Florida in 2000. And we would run across it every once in a while where a Florida trust was holding the title to the property in North Carolina, maybe. And that's really the very first time I started dealing with it. And we learned very quickly that, that's a Florida trust. So we go by Florida law as to how that trust is administered. And that's the situs of the trust. That's the basis of it. That's the law that governs it. So in North Carolina, we don't need to worry about who the beneficiary is. We don't have to worry about anything else. That trustee has full power to do anything with the property, mortgage it, sell it, lease it, whatever they want to do. And we just had the trustees sign off.
Nice. So the trustee, if it's a Florida trust, then the trustee has to be in Florida, even though the property is in, like, say, North Carolina. It can't be a trustee in North Carolina, can it?
Yeah. Yeah, it could be. It could be a human being or someone who is licensed to do business up in North Carolina. They could act as trustee of a Florida trust. And we also do this in the estate planning realm. I mean, it may be that you have a trust, a revocable living trust or an irrevocable living trust that you've set up for estate planning or maybe some asset protection in that regard. And now all of a sudden, the state where maybe Ohio, where you happen to be, that state changed their laws and it's not as favorable for asset protection. So we're just going to amend that trust and change the situs now to Texas or Florida or somewhere else that has better laws around, or Alaska even. So it's very common that you can change the situs of a trust. It's just land trusts are great in Florida because we got this statute that we wrote to be so robust about asset protection and especially anonymity, confidentiality of ownership. So no one ever has to see the trust agreement to see who the beneficiaries are.
Right. Nice, nice. I like that. So then again, like if I'm if it's my property, and I can technically be the trustee. If I have a property in North Carolina, I'm in Florida, I can set up my land trust. I could be the trustee as well for that property in North Carolina, pretty much.
Yeah, absolutely. And you could be your own trustee. So your name is going to be there as trustee. So you're going to lose some anonymity, but then you could have one of your LLCs to be the beneficiary. And then if you really wanted a lot of asset protection, that LLC's membership interest could be owned by an offshore trust or even a domestic trust, asset protection trust, if you wanted to go that route. But you could set it up to where that just gives you even another layer of protection inside the trust against outside people trying to come after you.
Yep, nice. Now, how is it looked at? Like, for example, let's take Florida. Let's say it's a Florida trust, Florida property, right? But or actually, let's go back to the scenario. Let's say it's a North Carolina property, but it's a Florida trust, but the LLC, the beneficiaries are Wyoming. So I've heard that if you rent that property out and you go to evict, that state may have an issue because that they don't recognize that property or the ownership in that state. Does that make sense what I'm saying? The question?
Yeah, and they shouldn't. They shouldn't be that way. Unfortunately, in a lot of states, well, in most states, fortunately and unfortunately, most evictions are handled in small claims court or county court or, municipal court, whatever it is, or even surrogates court or landlord tenant court if they've got that special, if they've got a lot of landlord tenant, like in New York. And so you're dealing with judges that are just simply unfamiliar with it. But in that case, the trustee should be able to sign the pleadings and everything. Now, in most states, it doesn't matter. I mean, if it's owned by an LLC or a trust, either way, if it's not a human being, they're going to, like in Florida, they're going to say you have to be represented by a lawyer because it's a separate thing. It's not the human being showing up here. You can always represent yourself in court, but as soon as you walk in that party is an LLC or a corporation or a trust, and if anything gets contested, a judge is going to go, you need a lawyer. So you go and you get a lawyer to represent you. But yeah, then the trustee is the plaintiff in the eviction or the petitioner, and they file the eviction or ejectment, depending on what it is in the state, and they push it through. Usually a local lawyer is going to push that through. And then as long as the name matches what's on the deed, the plaintiff's name matches what's on the deed, the judges are typically, I've never heard of a judge ever say, well, we're not going to let you do this. They push it on through and it's fine.
So that you think that's pretty much a myth then, that saying that since you don't, because I mean, the way I look at it is like, there's people that live out of state all the time that own property here. So
Right.
it's, I don't see that how that could have been a problem, but that's kind of like the myth out there. Oh, you have to be registered your LLC in that state if you're going to be a landlord and you evict them out. That's what that's kind of the myth type of thing.
Well, that is, if you do it directly, that is true. Because let's say it is Florida. Let's talk about Florida for a second. So if you have a Wyoming LLC that happens to own your real estate in Florida directly, or even as trustee of a trust, and it's a Wyoming LLC, number one, I'm always wary of that because they are so anonymous that and having done title work for so many years, I saw Wyoming LLCs come in to sell properties, to mortgage properties all the time. And unless I knew, like Mark's coming in and I know it's Mark's LLC in Wyoming and Mark's selling this property or Mark's putting a mortgage on his property, I know you, I was fine. But some stranger walks in and says, "Oh yeah, by the way, that's held in a Wyoming LLC. Here's certified copies of the articles." They got that straight offline. You can get that. You can order that. And then they hand me an operating agreement. And I go, "Okay, well, I have no reason to believe this is not the operating agreement that shows that you are the manager and you are the owner." And then they sign an affidavit at closing. We record it, they sell it, they mortgage it, they get the money. And then weeks later, we find out that that was not the owner of that company because it's so anonymous. And so you're always going to have that problem. Now, back to your question of, well, but can they file an eviction? Can they file any lawsuit? And the rule in Florida is if you are a company doing business in the state of Florida, you have to have registered as a foreign entity in the state to bring that suit, to have standing to bring that suit. And yeah, a tenant can get that dismissed if you haven't gone through that ministerial act of filing that paperwork with the state to get that. Because renting property is doing business in the state of Florida, renting property out. And so we always tell people, it's like, yeah. If you're renting property out and you own it in an out of state LLC, you're still going to have to register here. Sorry, you're going to have to do it. So that's another reason. There's two reasons then we like the land trust. And if you want to keep the anonymity, use a third party trustee like us in Florida to be your trustee because we're a Florida entity. So we can sign and file evictions all day long. Number one, we can prosecute any kind of lawsuit. We can sue and be sued already in Florida, but your name stays off of it. But by the same token, you're also anonymous. You're anonymous, but we're not. So any title company, if they get somebody walking in saying, "Hey, we're selling this property, we're mortgaging it," they're going to find us online. If they don't know us already, they're going to contact us and say, "Hey, we see that you're selling this property," and we'll be like, "We are. We didn't know we were selling it." So then we contact our beneficiary, who we know is right, and we go, "Hey, you didn't tell us you're selling the property." And they said, "Because we're not." And we go, "Okay, then we'll stop it. Somebody's trying to sell your property and take the money." And so we just nip it in the bud right there. So it adds that layer of fraud protection for you as well, using a known third party trustee. Now, if you're just using, somebody off the street or a relative, yeah, I can't tell you how many times I was presented fake IDs at closings over the years. I mean, it was a very common thing to have granddaughters walk in dressed as grandmother and have grandma's ID with them and say that, yeah, I'm selling this property or I'm buying and I'm putting a big mortgage on this property and I'm going to take the extra cash and keep it. Fraud is extremely common in closings, especially in Florida. It's rampant. And so anything you can do to remain anonymous, but not too anonymous, is always a good thing. And then also, you don't have to worry about, you can still have your Wyoming LLC be the beneficiary of the trust. So you still have your anonymity too, but at least if somebody tries to sell or mortgage the property or even lease the property, we get that one too. Then it comes back to us and we verify that you are truly selling, leasing, or mortgaging the property, refinancing it before we sign anything, and we can catch that fraud before it happens and stop it.
So I'm a little confused because we were talking about the scenario of North Carolina that you don't have to be registered in that state if you're a tenant, but then you said that you have to, or is that because you're a registered if you have it in a trust? So I'm a little confused. Does that make sense?
As long so let's say you've used a Florida trust and you're holding North Carolina property.
Correct.
Your trustee,
and you're renting it.
Yeah, and you're renting it out. Your trustee will need to be a Florida resident. I'm sorry, a North Carolina resident. So they must be a human being who lives in North Carolina or who can at least walk into North Carolina and walk into court if needed. If it's an entity, same thing. You're going to have to be an entity that registers in North Carolina as a foreign company to do business there. And that's the thing. Like us, we're not registered to do business in all the other states, so we don't do it. If a title insurer like First American, Fidelity, Chicago Title, somebody like that, is your trustee, they're already licensed to do business in the state of North Carolina and every other state just about. So they could do it. They typically will not do that service outside of either Illinois or Florida or Indiana, but they will do it in those states. But yeah, you typically need to find someone who can do business in that state wherever you have
Got
it
it.
in a land trust, even if it's in a Florida land trust.
Got it. Okay. That makes sense. That totally makes sense. And I've heard sometimes they will use a property management company and have the property management company handle the eviction. I've heard
Yes.
that too.
Yeah. Yeah. That's very common as well. I I'm a big advocate for using property management companies. I know a lot of people, the more properties you get, the property management company really eats into your profit and your yield. But if it's especially if it's out of state, I mean, I can't imagine having to deal with tenants out of state myself. And I do. I have clients who have properties here in Florida and they live out of state. And every once in a while, they have to fly down here and deal with clean out and fix up and renovate and re-rent and lease it back up. And I'm like, how much money are you losing doing that if you just used a property manager to deal with all that junk? And two, property managers typically get better deals on repainting and carpet and air
Yep.
conditioning and all the other stuff than you can because they do so much of it. Their pricing to get that done for you is pennies on the dollar compared to what you'd pay if you went directly to the vendor and had it done yourself.
Nope. Yep. I totally agree 100%. I mean, especially if you do a good one, you may have to go through a couple to find that good one. But
Yeah.
also just, do your due diligence and do research, nowadays with Google, see how long they've been online, look at the reviews. Definitely, property managers. I've had some horrible property managers, but now that you've been doing it long enough, you kind of have a good understanding of what to look for, and
Yeah.
and just kind of learn from the past. Now,
Yeah.
let's talk a little bit about the back to the land trust, the beneficiary being like an example of a Wyoming LLC. How many what do you recommend, and how many land trust properties should be held by one LLC? Because technically, if something happens to that property, right? Say somebody falls down, gets hurt, couldn't they penetrate that trust and get to the beneficiary? And couldn't they go after all the other assets within that LLC, other trusts that are owned by other real estate?
Okay, couple of questions there. Number one, they can't penetrate through the trust. They can't pierce that veil
Okay.
unless that beneficiary has directly done something to cause that problem. So that's why number one, I always tell my beneficiaries, you don't sign anything. Don't sign leases. Don't sign permit applications. Do not sign construction contracts. Don't sign sales contracts. Don't even, just don't. Have us sign it as trustee. Always have the trustee sign it because as soon as your name is involved, even if it's just as a property manager or as a recipient of the rents on the lease, that that ties you to the railroad tracks. And now here comes the train that's going to run over you. And we get sued regularly as trustee for personal injury. I've got a case right now where somebody a guest slipped and fell in a property and hit her head, and they're suing Morgan and Morgan, suing us as trustee of that property, saying that we didn't fix the roof, so the roof leaked into the house, and she slipped on the kitchen floor and hit her head. Whatever. So that is definitely, but we had signed the lease. We were the insured under the liability coverage. Our beneficiary had also named themselves as an insured. So there is insurance dealing with this and paying for the lawyers to deal with that kind of situation. But then sometimes you may have discrimination, tenant discrimination. And if you've signed that lease, or if you have listed you yourself as the beneficiary, as the recipient of the rents each month, they're going to throw your name on the complaint as a defendant because they're going to go, well, you're getting the rent and they're the name of the owner of the property. So we're going to sue you both. We're going to name everybody. Oh, and if there's a property manager, we'll name them too. You just name everybody and see who has insurance and get as much as you can as a plaintiff's lawyer. I know because I used to be a plaintiff's lawyer years and years ago. I used to sue people for these kinds of things. That's what I did. And now I'm sort of on the other side. So that's number one. Number two, So always have your trustee sign everything as trustee, everything. Never sign anything yourself as the beneficiary. Number two, typically it depends on the type of property and what it is that's being held. If the land trust is holding mortgages, where our mantra is, our advice is, you can have tens of thousands of mortgages being held by one trust. There's no reason to form a separate trust to hold each mortgage. Just depends on who the beneficiaries are of the trust. If they're the same, then just one trust holds all the mortgages. If it's vacant land, a lot of times I'll ask a lot of questions about the vacant land. How is it maintained? Where is it? Is it do people walk across it? Does this happen? Does that happen? And depending on that, a lot of times I'll advise that, yeah, it's okay to hold multiple parcels of vacant land in one trust. Where I draw a bright red line, though, is if it's an improved property, commercial or residential or industrial, whatever, if it's improved in any way, that needs to be in its own land trust. Nothing else is in it except that parcel of property. Don't put anything else in it, because now it's in its own little bubble, its own little basket over there. And if anything happens at that property or with that property, it's not going to contaminate everything else you've got. And literally, contamination is one of those things. Environmental contamination would be one of those issues if it's a commercial property or industrial, that if you own multiple properties in the same trust, if anything happens with that property, it's now contaminated every other property you hold in that same trust agreement. The trusts are cheap, they're fast, they're easy to set up, they're simplified. There's no need to worry about going, well, I'm only going to do one trust and put 4 pieces of property on each trust to save money. Don't worry about that. Don't do that. Just go ahead and have the same. You can have the same beneficiary, the same LLC, maybe a Wyoming LLC or Nevada LLC or Delaware LLC, be your beneficiary of all of your trusts, but have a separate trust for each improved property. Absolutely. Bright red line on that one. And I never waver from that advice. That's always a given. And now the next question is, so if I don't want the rental money coming straight to the beneficiary, then who should it go to? And our advice is typically, okay, well, let's form another company that acts as your operating company. And that operating company will receive the rents on all your properties. And that can be another Wyoming LLC or a Nevada LLC, Delaware LLC. Anyway, it sets up a bank account. All of your tenants, all the money comes into that. That company then pays mortgages, repairs, improvements, whatever it needs to pay, utilities, if it has to pay utilities. If it has any employees, it'll pay that. And then whatever's left over every month, it just immediately dumps the money over and into the account of your beneficiary LLC. That's the beneficiary of all your different land trusts. That separates all the properties away from each other. They're separated away from the beneficiary, and the beneficiary is now even more insulated away so that it will never be named in a lawsuit. If anyone's named, it's going to be the land trustee, the operating company, which has nothing, and that's it. So they can
So you
touch
do
that
set up
property.
an operating. So you do set up an operating company too?
Yeah, a lot of times we set up a separate operating company that does nothing but it collect the rents, pay everything for the property, and then whatever
Okay,
money's
I
left
got.
over,
Yeah. I'm
it
sorry,
dumps
I
over.
missed.
Yeah,
I thought what you're
yeah,
saying. I thought you
yeah,
meant another company. So you could technically you have 10 rental properties, and you're saying put them all into one trust, and then have the LLC, Wyoming as the beneficiary. Is that what you're saying? Instead of having 10 separate trusts?
No, definitely have 10 separate land trusts. If you have
Okay.
10 rental properties, each one would be on their own land trust, but you'd
Yep.
have one LLC that's the beneficiary of all those land trusts, and then you'd have one operating company out there that does nothing but accept rents
Yep. Got
and
it. Yep.
operate the properties. Yeah.
Yep. Totally makes sense. Yep. That's how typically I've always done it that way. But
Yeah.
okay. Yeah. It's just, but they can't, because, you also, the myth goes around like if if something happens in that property and they find out who the beneficiaries are, if it's an LLC, then they could get to all the other assets in that LLC. But I like what you're saying.
Yeah, that question comes up a lot. And I actually had this come up last week. I was doing a consultation with a client, and I told him, I said, look, we've been trustee of thousands and thousands and thousands of properties, and at any time we've got about 2,000 under trust management. And we've had 2 occasions where the plaintiff's lawyer has tried to pierce through the trust to the beneficiary. One was the trust had been dissolved and it was done. The property had been sold and they were trying to come after the beneficiary. Didn't work. Another one was the trust was still active and they were trying to come after the beneficiary. Didn't work. And part of this, I mean, goes to number one, we have no case law on it. But number two, so what happens in that case is judges go, well, we don't really have case law as to how you pierce through to go after the beneficiaries, but we have no reason why you can go after the beneficiaries, because the beneficiaries, you have not given one claim to say that this human being or this LLC has done anything to you. So not even knowing who that person or that entity is, why would we allow you to then just go through it? It'd be like, and they make it akin to piercing through an LLC to go after the members, or piercing through a corporation to go after the shareholders. And in Florida, which, by the way, Florida is one of the best asset protection states in the nation. The only thing it doesn't have is it doesn't have charging orders on single member LLCs, and it doesn't have some other little protection. It doesn't have domestic asset protection trusts like maybe Alaska has, but otherwise, for the most part, and it doesn't have series LLCs, but for the most part, it's a very good state for asset protection. But Florida is very, very, very tough to pierce any veils. One of the first things you have to prove to pierce a veil is you have to prove that the entity was set up with a fraudulent intent or a criminal purpose from the get-go, from the day it was opened. This LLC was set up to run an illegal casino, a gambling operation, or a pot farm that's not licensed, something like that, or it's a money laundering thing. So if you can't prove that first, that's your very first step to get through the veil. So they look at trust the same way. They're like, well, was this trust? No, this trust was just set up when they bought the property, and the property was just it was a condo that they rented out. So you have no inkling of any fraudulent intent here. So why would I allow you to even come close to piercing any veil on this? So very, 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 very difficult for them to do that.
Interesting. No, I like it. It's all the information that you're saying right now is huge, especially for people listening that are real estate investors, because we get so many different myths out there. What do you think the number one common mistake that people do when they are creating a trust, like a land trust or an asset protection trust? I know there's different type of trust, but what do you think is the number one common that you see over and over that tends to happen?
Well, the biggest one I see is they don't do their research on trustees, and they don't do their research on lawyers to create them. And I teach other lawyers about land trusts quite often. And people will come to us and they're like, well, I paid $5,000 for this land trust, and my sister is the trustee of it. And that, number one, is a red flag to me, because I'm going, why in the world did you spend $5,000 for a land trust? That's insane. That's an insane amount of money. And even talking to estate planning and other asset protection lawyers in Florida, they talk about how much they charge for a land trust. And I'm like, you're ridiculous. That's insane to be charging that kind of money for that. And then using a friend or a family member. We had one guy, he insisted that his mother was going to be the trustee of his land trust. And my paralegal kept telling him, it's like, well, okay, they get sued, they get this, they get that. And he said, nope, I'm not going to spend money on a private trustee, a third-party trustee like you guys. I just don't want to do it. I don't want to spend that annual, $165 fee to be our trustee. So my mom's going to do it. Literally 2 weeks after we set the trust up, got the property in there, his mom receives, a foot-thick federal district court complaint from a tenant saying that she had discriminated against the tenant based on familial status and in the renting of the property. And it was a sting operation. And his mom calls him. She's screaming at the top of her lungs. I just had a U.S. Marshal show up. I've been handed a foot thick of documents. It looks very bad. They're saying that I discriminated against them. Now my name is associated with being a discriminatory landlord. No, why did you put my name on this? So then he called us back and he's like, hey, my mom just got served and we want to make you guys the trustee now. And we're like, well, that's great, but it's too late. Her name has now been put in the federal docket. as a defendant in a lawsuit like this, in a discrimination lawsuit. So, that's number one, who you choose as your trustee. We had another guy, he chose his best friend and assistant. She'd been his best friend and assistant for decades. And then she got in trouble and she ended up taking the property out of trust, giving it to her and her husband, take out a $500,000 mortgage, and then put it right back into trust after she took the $500,000 out on the mortgage. She put it in her bank account, spent it all, and then never paid it back. So it went into foreclosure. So, if you use a trusted third party trustee, number one, it's usually going to be faster, cheaper, easier to do. Plus, you've got a third party trustee. And one of the things too, we tell everybody is like, we're lawyers. Mark was a lawyer. I'm a lawyer, and Mark's retired now. Mark still is a lawyer. He's just retired, but uh, we're always lawyers, and we have a lot on the line. So if I shoplift at Target, I can lose my law license. So of course, if I do anything with your property that is illegal that I should not have done, I'm going to lose my license. Why would I ever do that? I mean, we have properties in our trusts that are worth $100 million. And I still we never even consider doing anything with those, because it's like, it's still not worth losing our reputation, our livelihood, and everything else we've built over almost 30 years. We're not going to throw that away for anything. But your best friend, your assistant, yeah, they got nothing to lose. So
Yep.
they're gonna do whatever they need.
Yeah, and that's the biggest thing that I hear from investors that are uninformed or that don't understand a lot about trust. They hear the basics. Oh, I'm afraid to put somebody else I don't know as a trustee because they could take my property and run and cause problems. That's the biggest thing that I hear over and over from people. I'm going to make this person the beneficiary. I'm sorry, make this person a trustee, and then 30 days later they resign, and then I'm now the trustee. And then that's the big thing that I hear out there. I'm sure you probably hear that as well.
Yeah, and that's a big one. I know the lawyer who's out there doing that. He's not a Florida lawyer. And he's always saying, okay, you make so and so the trustee and then they resign, but you don't record that. And I go, okay, well, that's great. But guess what? That's still the person who's going to be getting the tax bills. That's still the person who's going to be receiving lawsuits in the future. We've had one where the trustee had died years before, and the lady thought she was being coy, and she never named a new trustee. And now it's causing all kinds of problems for her, because now she's trying to do anything with the property. And it's like, well, he died, and there was no successor named, and now we don't have anybody named, and we know how to fix that. I mean, we know how to fix that. We wrote the statute to make the ability to do that, to fix that problem. But a lot of people think they're being smart by saying, oh, well, no, they're not really trustees, so we really don't know who the trustee is, and yada yada. That doesn't cut it, folks. It's playing games, and and the courts don't like playing games. But if you walk in there and it's a third party trustee who's standing there and saying, yeah, and I've had to go into court before and say, Your Honor, I'm typically not representing the trust as the lawyer. I'm there as a litigant, and there's another lawyer. But I stand up and I'm like, yes, we're the trustee of the trust, and we have over 2,000 properties in trust across Florida. We've written the statute, we've written the book, we've written everything about this law in Florida. And so, if you have any questions, Your Honor, I'm happy to answer them. But we didn't do anything. This didn't happen. What the other litigant is saying about what we did, what this property did. I've been sued personally. I got named last year in a lawsuit personally for apparently poisoning and then killing a neighbor's tree in Lake County. And I hadn't been to Lake County in 5 years personally, but they named me, and I ended up having to go up there and, deal with that, which was fun. But in court, but that's the kind of thing. It's just what we do, and we're not your mama getting served by the U.S. Attorney's Office. We get queries from FHA inspector generals. We get subpoenas from the U.S. Attorney's Office. We get FBI subpoenas. We get hit with all kinds of crazy lawsuits all the time. But we're not going to freak out and go hide or put our head in the sand. We step up to it. We send it to the client. The client calls us back the beneficiary that calls back screaming like, "Oh no, what do I do? What do I do?" And we typically have lawyers all over the state who we recommend, "Oh, you probably need to call this lady. That's what she does. She litigates the crap out of these things and she'll defend it. She'll fight for you." And we work with lawyers all over the state all the time defending us, or as plaintiffs, either way. Very common. And another big one is if you're developing property, whenever you build something, even if it's a mobile home, you put a mobile home on a lot and you fixed it up, you could be on the hook for up to 10 years after that. But if it's in a land trust after you've sold it and you've taken the money, okay, they decide 3 years from now, they discover a defect. They're going to sue the seller, developer who built the thing. They're coming after us as trustee of what now has nothing in it. So fine, get a judgment against us as trustee of that trust. It's got nothing in it, and you've won your lawsuit, but it's a Pyrrhic victory because you just spent a lot of money to get an empty bag with no money in it. Is what you got.
Got it. Got it. Now, what about like with inside the trust, the land trust, the beneficiary? Like, technically, couldn't I sell my interest in the trust as a beneficiary to like my sister type of thing, or like that can be done as well? Isn't that correct?
Yeah, we do a lot of beneficial interest sales. It's actually a very common exit strategy for real estate investors. So let's say you bought a property subject to the mortgage, or you bought a property and you paid cash for it and you want to sell it, but you're not getting enough down to really do an agreement for deed or a note and a mortgage. So instead, you enter into a beneficial interest sale, conditional. And so you sell them the beneficial interest in the trust, and they sign a note, and they also sign a security agreement and a conditional assignment, and you sign a conditional assignment of beneficial interest saying, "Hey, I'm selling you the interest in the trust. And so long as you pay the taxes, pay the insurance, keep the property up, pay my note to me every month and do everything you're supposed to, it's your property. Fail to do any of that, and I'm repossessing the beneficial interest and it's my property again." So you're not having to go through a full-blown real estate foreclosure at that point. So that's a great exit strategy to leave a property. Typically, when you do that, you are selling it off to another investor who's then going to hold it and rent it out. But it's just a great way for you to take back the property without having to go through a full-blown judicial foreclosure. You just do a quick non-judicial foreclosure of the personal property interest and just take it back that way. And we do a lot of those. We've got one client, he probably does 4 or 5 a year. Another one probably does about 10 a year of those. That's how he exits. So selling that way. Also, it's a great way because whenever you do sell like that, that is not a recorded transaction on the official records. So the documentary tax is paid directly to the state. It's not published on the county records. So no one knows what you sold that property for. So it doesn't affect valuation in that way. There's no change in title. So the caps remain in place on the property. If it is non-homestead, we do have to let the county know on a Form DR 430 that the interest in the trust has transferred hands, but we don't tell them how much it was for or anything like that. We just say it transferred from this person to this person, boom, and it's done. And that's private records, confidential. It's not published to anybody. It's just kept at the property appraiser's office for future reference if they ever need it. But yeah, that's a very, very common thing, selling the beneficial interest in the trust.
You hit the nail on the head because there's a lot of, again, myths. Oh, if you do it this way and you sell it, you're avoiding, the tax, the transfer taxes. But you were saying that you guys go ahead and still record that and pay for that. So that answers that question because I've heard that floating around, that type of strategy. Yeah. But then they're like, oh, they're avoiding the transfer taxes. I don't know if you've heard that before, but you said you
know, yeah, and we know. I mean, whenever you don't have a professional trustee as the trustee, and they're not telling you that there are people who will just assign their beneficial interest for $100,000 and not pay the $700
right.
documentary tax to the state. That is illegal, and we do know cases where if that happens on a regular basis, the state always finds out. Department of Revenue in Florida, I mean, they've got hundreds of lawyers in Tallahassee, and that's one of the things they're looking for. And they'll see that, and they definitely investigate and come in, and they will slap a tax lien on the property, a tax warrant, and it's for the amount of documentary tax plus 10% a month for every month that remained unpaid for over 30 days after the transaction happened, up to 5 months. So you may have the tax plus up to a 50% penalty plus interest
Wow.
on the overall amount, and that stays on the property for 10 years. And so we've seen tax warrants hit properties before for homestead exemption, fraud. We've seen it hit for non-payment of documentary tax, things like that. So it does happen. And this is the thing. Everybody's like, "Oh, Joe, you're always full of the worst stories that could ever happen." And I go, "Well, yeah, I because I've seen them." And a lot of people talk about, "Well, this could happen and this might happen." Joe says it because Joe has seen it happen. Joe has been involved in fighting with the Department of Revenue and dealing with these issues. I have seen the horrible, injuries, the discrimination claims, the construction defect claims, just one thing after another. We've seen it in reality, so we do know it happens. And yeah, unfortunately, we see the worst. By and large, fortunately, most things are without a hitch. But when it is a hitch, it's bad. It's really, really bad.
Yep. But you're saying, oh, you're the, Debbie Downer type of thing, giving bad news, but that's how you learn is through that process. And you want to learn from other people's mistakes. So you learn to do the things the correct way. I can't tell you, I'm out there very active on social media in different groups, and I see people talking about, oh, you can do this, this, and this. And I'm like, no, you got to educate yourself. You're taking advice from people on social media. Do your research, do your due diligence. There's this one method out there. I'm like, you know what? If you want to know the truth and you want to figure it out on your own, call up the mortgage state regulator and run this scenario by them and see what they tell you. Oh, why would I want to
Yeah.
do that and put my name on it? Well, if you have nothing to worry about, then what are you worried about? So it's the same
Right.
thing. I'm a big advocate on just making sure people are educated the right way so it doesn't hurt our industry. Because if people are doing things incorrectly and it hurts our industry, regulations come down and then certain strategies and certain things will go away.
Right. And a lot of people think, well, it's sort of like taxes. Well, I don't have to really report this, and I can fudge on that. Nobody's ever going to catch it. Nobody's ever going to catch it. And unfortunately, I've seen they do catch a lot. You'd be surprised at how much they do catch. And when they do catch it, it can be ugly, and especially like the mortgage issue. I mean, I've had clients, very upstanding clients, where the criminal investigation division is coming after them for uh, practicing mortgage lending without a license. And we have to send them to a criminal defense lawyer, not a regulatory defense lawyer or civil defense lawyer. They're like, yeah, you're facing 15 years in prison for what you've done. This isn't because you did it over and over. And fortunately, they were fine. What they'd done was fine in the end, but it took a criminal lawyer to go in and prove that
But
during the
but you know
investigation.
but what's really sad is that people don't know what they don't know, and they're learning
Yes.
things from the people that are being incorrect. And I can't tell you how many times I see new investors coming in there trying to do these creative strategies, and they think, oh yeah, this is perfectly fine, but it's in reality it's not. So and then you get really defensive when you try to attack them. Oh, you're just like I'm like, we're just trying to help you because you don't know. I mean, whoever's teaching it's not the one that's going to go down, it's you, because you're the one that's doing that, whatever. So just inform and educate yourself, just like what you said earlier about the trust. So Joe, we're almost coming to the end here. Is there a question that I did not ask you that I should have asked?
Uh, Not that I can really think of. I mean, I agree with you on the social media, and that I was talking about that in one of our internal meetings this week here at the firm. The biggest pushback that I get is because people are out there and they're consuming lots of social media, which I agree. I mean, education is great. And even watching, especially if you're watching other attorneys talk about, hey, this is a land trust, this is an LLC, this is how you can do this, how you can do that. But I'm on social media, so that's usually how they end up to me is they've listened to this guy out of Utah and this guy out of Nevada and this guy out of New York and this guy out of Ohio and Pennsylvania, and then they end up finding a person in Florida, me. and they end up on our channel, and then they go, okay, well, you're saying a lot of similar things to them but a little bit different, so let me go to you because you're a Florida lawyer, my property's in Florida, or I live in Florida. And I get them and I talk to them. And what people need to understand, information is free. And everybody expects I'm paying nothing for information, which is an education. It is free. It's the application you have to pay for. Applying that information to your particular situation, applying our experience to that particular information. So a lot of people come to us and I'll go, oh, okay, yeah. You don't need 7 or 8 LLCs and 7 or 8 land trusts and another company for this and another company for that. And you don't need that. That's a waste of your money. And the biggest pushback I get is, well, no, but this guy in Utah told me I do. And you're telling me I don't. So you must be wrong because he's got 3 videos and you only had 1. Things like that. So that's the biggest pushback I'm hearing every day now. People want to spend more money than they really need to. And I'm going, look, I'm telling you, I'm applying the law and my experience to your particular facts. You don't need to spend all of this money. You're just burning cash that you could be, I mean, and it can be as high as $20, $30, $40,000 that they're wanting to just burn. And I'm sitting there going, why? You could put that money on a down payment on another property and buy another property and have it rented out. And instead you want to just burn it on too many entities and too much complication in your life that you don't need. And so that's what I'm seeing is education. You can either have the experience or the person that you're working with can have the experience. And I've always said, either way, it's an education. And sometimes that education is the cost of tuition at Harvard. When you make that mistake, but wouldn't it be better to just spend a little bit of money with someone who has really experienced it and someone who really does have the knowledge of your particular situation and your law that applies to you, and just let their experience for a few $100s avoid that tuition to Harvard that you're going to have to suffer through yourself. And I can tell you, people too, I mean, as long as the economy's booming and real estate's going up in value, it forgives a lot of sins and sloppiness and chaos. But as soon as that market turns down from a 10 to a 9, that's all it takes a lot of times. Like, I saw it in 2008.
Yep.
The whole house of cards comes crashing down and everything always snaps back to that median. So stock market's booming, eventually it'll come back down. Home prices are booming, eventually they'll come back down. Interest rates are going up, eventually they'll come down. So everything always snaps back to a median. And someone who's been like you, Mark, or me, we've been doing this for decades, thousands of transactions. We've seen a lot. So if somebody's listening to people like us, don't ever, poo-poo our advice. Don't ever poo-poo our experience, because we are simply trying to help that person not go through that educational experience that we had to go through, which was very painful and very expensive. So that's the big thing I always push out to people right now.
Yeah, I see that all the time. I can't tell you how many times I had a call not too long ago with this guy purchased a subject to deal from a student that went through a course that was $10,000, and they did an assignment, and then they used a transactional coordinator that was like certified, and the whole thing was screwed up on so many different levels. The bottom line is that they were ending up getting sued by the seller for $130,000 because they screwed it was screwed up on so many different levels.
Oh yeah.
I was just like, I'm like, oh my God. And like this and that. And I'm like, and they didn't want to pay somebody professional to teach them the right way. I'm like, oh, I'm going to try to do this on my own, blah, blah, blah. Oh, this person that went through this $10,000 course, he knows what he's doing. He can teach me how to do it. And then they're using a certified person that transacts. And I'm just like, oh my God. And they're out there giving legal advice, and they're not even attorneys, and the advice is incorrect. I'm like, wow. So like we see it all the time. So listen to people the way I look at it is, you want to see people that have been around it for at least 10 years plus. At least 10 years plus. And even then, you're still learning through the process. You know what I mean?
Yeah. And every day we still learn. We're always learning. If you're not learning, you're there's something wrong. But yeah, you're always learning something new every day. And the thing is finding people who are exposed to thousands and thousands of transactions, have seen a lot, and
Mhm.
we're not saying that you're going to come to us and we're going to say, oh no, don't do anything. Just go hide in your house and close the blinds and don't get out of bed. We're not doing that. We're just going, okay, yeah, we can make this happen, but this is how we're going to have to, this is the best, safest way to do that. And, and keep you out of trouble.
Just protect
So
yourself.
that's all we're doing. Yeah,
Yeah.
that's all we're
And you could
doing.
do extremely well. If you do things the right way, you can do really, really well and become really wealthy in this industry. So,
Oh.
Joe, thank you so much. How can people reach you and how can people find you?
Uh, for the trust company, it's mylandtrustee.com. Also for the law firm, it's aspirelegal.com. And if you want to learn more about land trust, the 11th edition of Land Trust in Florida, you can go to landtrustbook.com. Sign up there. You'll get a copy of the second chapter, which gives you all the reasons you would ever want to use a land trust. And then if you want to order the book, get the rest of the book with the forms and everything else, there's a spot there to go over to Amazon and get that ordered. So if you really, really want to learn a lot about land trust, landtrustbook.com is probably the best place for you to go for that.
That's great. And we'll also post all this stuff in the notes of the show below. If you're watching this on YouTube, we'll be there. If you're, wherever you're listening to us on your favorite podcast platform, we'll have all those in the notes as well. So, Joe, thank you so much for coming on. This was really informative. I actually learned a few things today, and I've been using land trust for years. So you educated me on a couple things today. So thank you so much for that. So thank you for coming on. I really, really appreciate it.
Thanks for having me.
Great. Have a great day, everybody. And thank you for listening to Real Estate Power Play. If you like this episode, please comment below. Thank you guys so much and have a great one.